Welcome to Transnational Competition Law course. And dear learner, today we are again going to discuss on the issue of the enforcement of extraterritorial application of competition law in developing countries. There has been a series of discussion on the issue of the enforcement of extraterritorial application of competition law. We have broadly identified that what are the major problems pertaining to the regime of competition law enforcement in domestic, regional, and transnational and global context. We also noted the fact that what are the issues pertains to the experiences which has been pulled out from John M. Connor's scholarly articles on private international cartel dataset guidance summary statistics of 1990 to 2016. We have also taken note of United Nations publication on the transnational and extraterritorial experiences in developing country published by the United Nations organization in 2021. And out of these two literatures, that contains the mines of information about the transnational or extraterritorial application of competition law in relation to the enforcement mechanism, in relations to the practices of the different states of the developed worlds, America, Europe, South America, Russian Federation, West Asian countries, African countries, India, and the Pacific countries. We have referred to a large number of cases to bring home the conclusion that how in different jurisdictions of the world that the competition law and policies of their domestic jurisdictions have come of age and trying and struggling very hard to put a dent on the anti competitive behavior, cartelization, predatory pricing, regulation of combinations, offshore mergers, and abusive behavior and the conduct of some of the firms in the domestic market. We have tried to see from the lens that what are the major hurdles and hiccups not only in the substantive competition law but in the procedural competition law, because even if we have the finest and the sophisticated substantive competition law, but if we'll be failing in having an adequate and concurrent and parallel sophisticated procedural competition law, then probably the question of enforcement of extraterritorial application of competition law will be failing to a great extent. And we have seen that even the best competition authorities of the Brazil, known as CAD, itself has admitted in one of the report that they have a large number of cases which are pending despite their meticulous investigation and their judicious delivery of their judgment and findings in an administrative and institutional setup. There are many cases which has been decided by the courts of law, even the highest and the apex court at different jurisdictions, but all those cases are just lacking some kind of the enforcement and executory mechanism. Dear learner, what we identified that there are large numbers of problems, hurdles, and hiccups in relation to the substantive competition law, and that needs to be neatly carved out to reach to a kind of a regime which can be cohesive, which can be effective, and we can provide a robust marketing system at the domestic level, regional, and the global level. In this context, now we will try to know that whatever the niceties are involved in the transnational or the regional or the national laws, we can find an alternate to address the problem of systemic reform and refurbishing of the procedural competition law in matters of enforcement, so that the kind of the hiccups and hurdles which are acting as a stumbling block have to be addressed precisely. In that reference, we will try to know many things, and the first and foremost is that we will try to look at the Hague Service Convention 1965 as to see that whether there is some international soft law or the hard law which can come our rescue for the effective enforcement of extraterritorial application of competition law in developing countries. We will also try to see that how the Hague Convention of 1965 squarely addresses to the issue of non-compliance and non-cooperation by many of the countries and jurisdictions which adversely affect the entire proceedings, and the appropriate international instrument, if they happens to be missing at this stage, then it means that they are real stumbling blocks which potentially arrest the entire free trade and the flow of goods and services and fostering competition across the globe. And then we will be finding that how we can hone out our strategy among the national level, among the competition authorities, to make the cooperation more simple, easy than of becoming cumbersome, how we can improve the bilateral ties, how we can have a kind of a engagement which can have some kind of a trust building between the agencies, how we can have a system of the collaborative and cooperative effort which can serve as the cornerstone of the enforcement of extraterritorial application of the competition law, and how the United Nations Conference on Trade and Development model law on the competition and their series of notification on the issue can serve as a handy guide to look at some of the major issues and major problems of enforcement, and how we can have knowledge sharing and trust building. In that way, we will be concluding on the issue that the transnational restrictive practices, business practices, continue to govern in the multilateral level. That requires our immediate attention, and some kind of a significant economic harm which are manifesting at the extraterritorial application of competition law and hampering the domestic competition legislation and market needs to be stemmed out. We have to look not only from the developed countries' point of view, but we have to be equally circumspect and careful to the developing and underdeveloped countries in looking at and in accelerating the entire pace of competitiveness. In that reference, what we find, dear learner, that the 40 countries which has been surveyed brilliantly by John M. Connor in his article on Dataset Guide Summary Statistics, encompassing a 26 years of study of different countries, have clearly spelled out that only 34 jurisdictions of the world have the clear textual basis for the enforcement of extraterritorial application of competition law, whereas this study also goes on to suggest that only 24 developing countries reported practical experiences and has been in a positions to review offshore merger, and only 14 countries have experiences with cases involving restrictive trade practices and cartelization. In that way, dear learner, we will just see that how these issues are to be resolved and how early it is to be resolved. that earlier is the better, that kind of a scenario must visit in the entire regime of the enforcement of the extraterritorial application of competition law. Now we will begin that whether, despite the niceties attached to the developed and developing countries in having their legislation on competition laws and policy, despite the existence of a large number of competition authorities at national level, despite the existence of the judicial organ and their timely decision on the issue of the competition law, we require a kind of a system which can serve as a fillip or that can serve as a filler to the void which has been created at the trans in extraterritorial application experiences, hurdles, and hiccups. Then we refer to the Hague Service Convention 1965 to see that how this can come as handy and can come to some rescue in giving some kind of a impetus to the reform which is lacking into the procedural competition law in extraterritorial application of competition law. In that context, dear learner and the viewer, we will just see that how Hague Convention have charted a multilateral service route, and it seems to be of a practical use in the sense that it in the competition law proceeding, the procedural rules plays a very pivotal role, especially in relating to service of the process, which are purely an internal matter, and internal court proceedings, an internal circular, and the official uh, protocols. So they can be amended domestically in the light of the international negotiations. In particular, what we find that the Hague Convention of 1965, that they have a detailed set of guide in relation to the international negotiations which can be brought into the domestic law, and that relates to number one is the notification, another relates to the publication. And in that context we find a common means of service that can be possible by way of negotiation or the notification or the publication, and we can make the enforcement regime very effective, taking some of the finest principles which are underpinned in the Hague Convention 1965. For example, the European Commission has availed the standard mail service for the purpose of service, whereas the Japanese rule we find have adopted that publication is the only means of serving some of the notices if other means fails. So the diversity of the procedures which are being adopted to for the service, that needs to be have, we can go for the diversity or we can cherish the uniformity of the rules. That in that sense the Hague Convention 1965 can be of a great help. The other practical issue which relates to the issue of the enforcement is partly addressed by the Hague Convention 1965, that it put emphasis on the collaborative solutions for accessing, collecting, and sharing of the evidences, because we have seen thoroughly that adducement of the evidences, corroboration of the evidences, and the cogent evidences, if somebody happens to be very meticulous in bringing and those evidences to the table of the competition authorities, or for that matter table of the court, but there is also a need of sharing of those evidences across all the jurisdiction, because sometimes the violator of remains one and the same, and it has a cascading effect on the domestic market at various jurisdictions. So in that respect, the Hague Convention 1965 spells out a very good mechanism of collaborative solutions, and that solution is one for accessing, one for collecting, and one for sharing of the evidences. And the sharing of evidences sometimes become very important because some of the countries are not in a position to access and collect the evidences. So they are mercilessly dependent upon the sharing of evidences by other sources. In that sense, that Hague Convention 1965 is of a great and immense importance, and whatever hinders the international or transnational enforcement and whatever the long standing issues which are pending, as we have seen in the case of the Brazil itself, the CAD accepted that even if we have some kind of a solution, but those decisions are pending. So, to overcome the long standing delay and the latches of the enforcement in transnational enforcement, we can find a kind of a succor, or if we find a kind of a relief under the Hague Convention of 1965. Then we also have another sets of the law, be that a soft law, is the United Nations Conference on Trade and Development, which has identified this problem as far back as in 1995, though it has not still addressed, but it has greatly contributed to the lacunae which are prevalent in the enforcement regime, and especially the UNCTAD, United Nations Conference on Trade and Development. A solution to the offshore anti-competitive conduct is something very important and very noteworthy, and it also have addressed to the issue of securing admissible evidences across all the jurisdiction, meaning thereby that the United Nations Conference on Trade and Development in 1995 have also allowed the sharing of the evidences and recognized it as a major problem. Thus, what we see, dear learner, that the international instrument that seeks to aid actual enforcement actions are widely considered inefficient or insufficient, but we can also refer in that sense not only the International Hague Convention or the United Nations Conference on Trade and Development, but we can also see the series of notifications and circulars which has been prepared by the Organization of Economic Cooperation and Development. Recommendation on cooperation is very important, and the Hague Convention on Evidence. These two things are equally important. And in 2014, the Organization of Economic Cooperation and Development recommendation, which concerns on international cooperation on competition investigations and proceedings, is very important, and the Hague Convention on taking of evidences abroad in civil and commercial matter of 1970 is also important. So we can see that the slew of reform which is manifested in the shape of number one, the Hague Convention of 1965, United Nations Conference on Trade and Development 1995, the Hague Convention on Taking Evidence Abroad in Civil and Commercial Matter 1970, Organization of Economic Cooperation's recommendation concerning international cooperation on competition investigation 2014 are some of the important milestones which can serve and which can fill the void which are prevalent in the substantive as well as the procedural competition law regime in matters of enforcement of extraterritorial application of competition law. Then the other issue, dear learner, happens to be on the enforcement is the issue of non-compliance and non-cooperation, because all the judgments of the competition authorities and the competent court are sometimes not observed in a right spirit and earnest and intent, thereby, and there are also cases of non-cooperation among the various countries. In this case, the issue of cooperation and compliance, which goes hand in hand, and then that issue needs to be addressed in cases of non compliance and non cooperation, which adversely and detrimentally affect the entire proceedings. And in that case, we will find that there is an appropriate international instrument which are missing, and we have to look for that appropriate kind of an instrument which can provide a kind of an impetus and flip to that. And till date, there is no single international agreement which provide for the recognition of the decisions and judgments in competition law matter apart from the award of damages. And that is something that a routine kind of a matter or in the enforcement beyond award and beyond fine and beyond imposition of some kind of a levy, that we don't have some very effective international precedent, and that international precedent which can serve and can guide the future cases of violation of the competition law. So that we have to look into, and we have to not only rely on a unitary kind of the remedy which has been given by way of the fines and the damages, but we have to look common types of sanctions in the conduct cases, and we have to also look some kind of a collectible evidences, and we should also have some of the finest judgment which can deter and which can serve as a general deterrence to the violators, and then we can only improve the we can only improve what you can say the entire enforcement regime on the competition law. Then what we can possibly pull out. So the idea is that the kind of a unitary remedy which we have been handing over through the edifice of the national competition authorities or the regional authorities or are not considered to be sufficient. We have to go for a very long term international trend setting precedent which can act as a deterrence to the violator, and then we can improve the enforcement regime of the competition law. And in that reference, we have to see actually that what are the stumbling block in matters of enforcement of the competition law, and what are the practical problems or how we can overcome that. And then we have to see the transnational anti-competitive conduct in a broader sense. And if we look at in a very dispassionate manner, then we find that the experiences and skills between agencies making cooperation is more cumbersome. Therefore, we require some agencies which have some bilateral ties. We should also look at some kind of an external political pressures which affect the decision making of the competition dispute, as we have seen in the case of the ANSEC case in the India and the South Africa and the domestic response to that cases. So we should not rule out the possibility of the extraneous factors which governs obliquely, directly or indirectly the entire regime of the competition. Therefore, what is required that let there be some kind of a trust building as a cornerstone of the cooperation and the compliance of the competition law. And we should look really that how the United Nations Conference on Trade and Development can be a very useful and effective platform to engage meaningfully about facilitating knowledge sharing and as well as the trust building among the different parties and agencies. And now, dear learner, what we can conclude that the transnational restrictive business practices continue to be ungoverned at multilateral level. Therefore, the significant economic harm which we have noticed and discerned by the extraterritorial application of domestic competition legislation needs a thorough revision and refurbishing and reform, as we have seen that out of 40 countries, in the article mentioned by the John M. Connor, that 34 jurisdictions of the world have provided a clear textual basis of the extraterritorial application and enforcement of competition law, whereas what we find only 24 countries having reported some practical experiences. It means that the 16 countries have not shared meaningfully that what are the major problems, hurdles, and hiccups in realization of the enforcement of extraterritorial application of the competition law, and only 14 countries have shared their experiences regarding the extraterritorial application of competition law, and that too only confined to the restrictive agreement and cartelization. In such a situation, what we can conclude that the extraterritorial application of competition law in developed countries and developing countries needs an effective enforcement regime which can goes well beyond the national laws, regional laws, and international law, but a series of soft and hard international law. With that, dear learner, I end my lecture, and I hope that now you have a very broad and a holistic understanding of the enforcement of extraterritorial application of competition law in a right perspective, and a binary of thoughts and a diversity of the thoughts and the richness of the experiences of across all the jurisdictions of the world. Thank you very much. Have a happy learning.